Hello, I'm Carl Oppedahl. I'm a patent lawyer in the United States. I'm here today to tell you why I'm excited about PCT-PPH, the Patent Prosecution Highway for the Patent Cooperation Treaty. In the next few minutes I'll be telling you about some good results that I've seen applicants obtaining using PCT-PPH, and I'll tell you the things that you can do to try to get good results yourself. How would you like to get a U.S. patent in 3 days? Or 11 days or 18 days instead of perhaps 2 or 3 or 4 or 5 years? How would you like that? Well, what we'll talk about in the next few minutes are some things that you can use to try to get patents more quickly in the USPTO. But I should emphasize that many of the points I will make in the next few minutes are equally helpful for getting patents quickly in other patent offices besides the USPTO. First, to talk about PCT-PPH, I have to give a little bit of background for what I will call ordinary PPH, the Patent Prosecution Highway as it has existed for about the last 4 years. The ordinary Patent Prosecution Highway talks about applications that are related by Article 4 of the Paris Convention, applications that were filed within 1 year of each other. These are patent applications where a favorable finding as to patentability in the office of first filing, the first application where the first filing was done, can be used to get faster prosecution in an office of second filing. Very recently, a new program called Oppedahl has been announced in which 8 of the PPH patent offices have chosen to broaden the ability of applicants to use PPH. Under Oppedahl, you can take a favorable finding as to patentability from any of those 8 patent offices, and you can use that to get faster examination in any of the other 7 patent offices that belong to the Oppedahl agreement. The thing about ordinary PPH is that it requires 2 things. The applicant needs to have enough money that they can afford to file around the world in 1 or perhaps more than 1 foreign country after their first country. They have to have enough money to do that within 12 months of the first filing. Then there's a second thing that the applicant needs. The applicant needs to have enough information to be able to make a business decision to proceed with expensive foreign filings all within 12 months. There are, of course, some applicants who have both of those things, enough money and enough information early enough to use ordinary Article 4 of the Paris Convention for their foreign filings. I'll tell you that with my patent firm, very few of the clients of my firm are in a position to do such filings. The clients of my firm usually don't have enough money or enough information, or both, to be able to make all those decisions and spend all that money within 12 months. For clients of my firm, almost all of them simply must use PCT. They must use the Patent Cooperation Treaty. Only with the Patent Cooperation Treaty can they get an extra 18 months to try to find enough money to pay for the foreign filings, and only with the Patent Cooperation Treaty can they find that they have obtained enough information to make their business decisions about which cases to do foreign filings in and which patent offices in which to do those filings. So we're here today mostly to talk about PCT-PPH. Now, how does PCT-PPH work? The way it works is that you file a PCT application and you select a searching authority that is approved by the patent office or patent offices that are your targets, the patent offices in which you hope to get fast examination. So, for example, if your target patent office is the USPTO, as of right this moment, the searching authorities that are available for purposes of PCT-PPH are Australia, Austria, European Patent Office, Finland, Japan, Korea, Russia, Spain, and Sweden. If you pick any one of those searching authorities, and if you then have the good luck to get favorable treatment of your claims in the international stage, you can then use that favorable treatment to obtain fast patent examination in the USPTO. What do I mean when I say favorable treatment? Well, What I mean is that either the searching authority has given you a favorable written opinion, or you have filed a demand and the preliminary examining authority has given you a favorable written opinion, or the preliminary examining authority has given you a favorable IPRP, International Preliminary Report on Patentability. If any of those three documents treats one or some or all of your claims favorably, then that is your entrance ticket to get on the highway, the Patent Prosecution Highway for the Patent Cooperation Treaty. Now, to be economical, I will use the term written opinion for all those things, but whenever I say written opinion, I mean any one of those three things treating your claims favorably. So, what do? You file a PCT application, you select your searching authority appropriately, you get a favorable written opinion, and you can then take a U.S. patent application and get it put on the Patent Prosecution Highway. What does that mean? That means the case is made special. In the USPTO, special means that the first office action comes very quickly. It means that if there is a second office action or a subsequent office action, they will come quickly, and if you have reason to appeal to the Board of Patent Appeals within the USPTO, the appeal will be taken up quickly. This is important. It's important because ordinary examination in the USPTO, depending on your technology area, might take 2 years or 3 years or 4 years or 5 years to get a first indication of patentability in a first office action. If you have reason to appeal, it is commonplace for appeals in the USPTO to take 2 or 3 or 4 years. So it's really helpful for your case to be made special, and it's and to get that, you can use PCT-PPH. What are the scenarios that permit PCT-PPH treatment? Well, the scenario is that you have a U.S. patent application. It could be a national stage from a PCT. It could be a national stage from some other PCT, perhaps a parent or child PCT application. It could be a bypass continuation. Any U.S. application that has an appropriate relationship to the PCT application in which you had your favorable written opinion. What is the relationship? It can be anything involving domestic benefit claims, Article 4 priority claims, anything. And the claims in the U.S. case must sufficiently correspond. What does sufficiently correspond mean? Well, it's common sense, really. If the PCT was filed, say, with 10 claims, 5 of which were found patentable in the written opinion and 5 of which were not, then in the U.S. case that's going to be put on the highway, you are only allowed to present the 5 claims that were treated favorably. And you can file dependent claims, claims that are fully supported by the application as filed and that depend from those 5 claims. Finally, you can amend those claims as necessary to comport with U.S. formal requirements. So, for example, if you had a multiple dependent claim depending from a multiple dependent claim, you could change that claim so that it's no longer a multiple dependent claim, which you would have to do to comport with U.S. formal requirements. So, as long as you have sufficient correspondence of the claims and some sort of continuity data or foreign priority relationship, no matter how distant, no matter how tenuous, a relationship with the PCT application in which the favorable written opinion was established, you can get on the highway. What are the filing requirements? Well, you have to provide copies of the references that were found in the International Search Report. So this means that as soon as you get your International Search Report, you should make sure that you lay your hands on PDF copies of all of those references. You're going to need them because they're going to need to be e-filed with the USPTO. The only exception to this is granted U.S. patents and published U.S. patent applications. You will not need PDF copies of those. Let's do a little bit of expectations management here. It is not the case that the U.S. examiner is going to automatically adopt the findings of the written opinion. The U.S. examiner may well reach a different view than the point of view reached in the written opinion. So it is not the case that we can assume that the first office action will always be a notice of allowance. Having said that, I can tell you that the allowance rate under PCT-PPH is much higher than the allowance rate for ordinary U.S. patent applications that are not on the highway. The number of office actions needed to reach disposition of the case is fewer than with an ordinary case. So there are many benefits to being on the highway. Let's think a little bit about the fact that you may already have patent applications that are eligible for PCT-PPH and you might not even know it. What I suggest that everyone do who's watching this video, go and check all of your PCT cases that have come to the United States within the last 3 or 4 years and look at the written opinions on the IPRPs one by one and see whether any of those happen to be favorable as to some or all of the claims. Such cases might well be good candidates for highway treatment in the United States. A couple of prosecution tips. When you file your international application, as you know, you have up to a month to hand in your filing fees. My suggestion is to hand in the filing fees right away. Pay the search fee right away. Why? Because the receiving office will not send the search copy to the searching authority until the receiving office has the search fee in hand. The sooner you get the search copy to the searching authority, the sooner they will establish your written opinion for you. When does the searching authority establish the written opinion? The searching authority is supposed to establish the written opinion within 3 months of when it receives the search copy, or within 9 months of the priority date, whichever is later. So keep that in mind so that you know when to expect your search report and written opinion. Now, if you have the good luck to receive a written opinion from one of the approved searching authorities, you could wait until 30 months has gone by to enter the U.S. national stage or to file a continuation to get into the U.S. Patent Office. But I suggest that you not wait until 30 months has gone by. Instead, I suggest entering the U.S. national stage or filing your continuation very promptly after getting the favorable written opinion. Then get the case put on the highway, and if you're fortunate, you'll get not only a fast first office action, but perhaps a fast allowance. The remaining thing I can say about this is that you can double dip. Suppose you get a finding of patentability using PCT-PPH from the U.S. Patent Office. Well, the U.S. Patent Office belongs to the Oppedahl agreement, and thus a finding of patentability in the USPTO will get you accelerated examination in any of the other 7 patent offices that belong to the Oppedahl agreement. So keep in mind the possibility of double dipping. Now, I'm enthusiastic about PCT-PPH. I'm enthusiastic about it because I have seen really good results for applicants. I've seen cases where a PCT-PPH request was granted on a Monday and the USPTO mailed the notice of allowance the following Thursday. That's 3 days. I've seen similar results in 8 days and 11 days and 18 days. This might work for you too. You need to be informed about PCT-PPH so that you can take fullest advantage of it. Your clients will ask you about it, so you need to be prepared. Having said this, I need to make one more point. There is nothing quite like the tedious and old-fashioned and exhausting business of writing a good patent application. We all know what it takes to write a good patent application. We have to draft the best patent claims that we know how. We can't do that until we've spent an enormous amount of time and energy talking to our inventors, learning exactly what the invention is, and going back again and again until we're very sure that we've figured out everything that needs to be claimed. Maybe we have to do a little bit of searching to have some sense of what the prior art is. But there is no substitute for drafting the best patent application you know how to draft. That is the application that is deserving of all of these efforts under PCT-PPH. Draft the best patent application you know how, use PCT-PPH, and I think you might see some good results, like the results that I have seen with other applicants in the USPTO. PCT-PPH. Learn about it and give it a try. Thank you.